What is a breach of trust? A trustee is a fiduciary, which means that they have the legal duty to act in the best interests of the trust beneficiaries. A breach of trust occurs when a trustee violates their fiduciary duties. In general, trustees have a duty to act in the best interests of the trust beneficiaries, to manage the trust property prudently, and to keep accurate records. And if a trustee violates any of their duties to the trust beneficiaries, then they most likely will have committed a breach of trust. In California, a trustee's duties to the beneficiaries include 1, adhering to the terms of the trust instrument, 2, acting in the best interests of the trust and its beneficiaries, 3, treating all beneficiaries fairly and impartially, 4, avoiding the use of the trust for their own benefit, 5, keeping trust assets segregated, 6, enforcing legal claims involving the trust or trust property, and 7, defending legal actions against the trust or trust property. Under the California Probate Code, a trustee who violates any of these duties has committed a breach of trust. If you have questions, give us a call, shoot us an email, or schedule a free consultation at rmolawyers.com. How do you handle a breach of trust? If you're a beneficiary of a trust, there are several things you can do if you think that the trustee has committed a breach. Under California law, if a trustee commits a breach of trust or even threatens to breach the trust, a beneficiary or co-trustee can ask the probate court to take any of the following actions. 1, compel the trustee to perform their duties under the trust. 2, enjoin the trustee from breaching the trust. 3, compelling the trustee to redress a breach by paying money or taking other action. 4, appointing a receiver or a temporary trustee to take over the trust and administer it according to its terms. 5, suspend or remove the trustee from their position. 6, set aside acts that the trustee has already undertaken. 7, reduce or deny the trustee's compensation. 8, impose an equitable lien or a constructive trust on trust property. Or 9, trace trust property that's been wrongfully disposed of and recover the property or the proceeds if it's been sold. Also, under California probate laws, if a trustee has committed a breach of trust, the court can also surcharge them or require them to pay any of the following amounts. 1, any loss or depreciation in value to the trust estate resulting from their breach of trust, with interest. 2, any profit made by the trustee by breaching the trust, again with interest. Or 3, any profit that would have accrued to the trust estate if the loss of profit is the result of the breach of trust. However, a trustee may also be required to pay exemplary or punitive damages where there is evidence that the breach of trust involved oppression, fraud, or malice. Punitive damages are additional compensation meant to punish the trustee for extraordinarily reprehensible behavior. Who can sue for breach of trust? Under California law, our probate code provides that any beneficiary or co-trustee can file a petition alleging breach of trust. Our laws provide important protections for beneficiaries and co-trustees by ensuring that they can seek relief from the probate court if the trustee poses a threat to the trust or has committed a wrong against the trust. What is the sentence for breach of trust? Although some breaches of trust can amount to criminal offenses, a trustee really will only receive a jail sentence for a breach of trust if they're convicted of a crime in a criminal court proceeding. Under California laws, embezzlement of trust property worth $950 or less is a misdemeanor with a maximum sentence of 6 months of prison time. Stealing trust assets over $950 is a felony offense, which can carry a jail sentence of up to 3 years. However, the reality is that the majority of breaches of trust are handled as civil matters through the probate court rather than criminally prosecuted. Typically, police departments, district attorneys, etc., just don't have sufficient resources to pursue these matters criminally. For these reasons, if a beneficiary or co-trustee believes that a trustee has misappropriated trust assets, the issue is typically resolved in the probate court with the assistance of a trust litigation attorney. It's rare for a trustee to be charged criminally or receive a jail sentence for breaching a trust, even if they've stolen or misused trust property for their own benefit. Have questions? At RMO, we protect people like you every day. Give us a call, shoot us an email, or schedule a free consultation at rmolawyers.com. Thanks for watching.